Hey everyone, it's Rob Ryder. Today is Sunday, October 29th, 2017. Blasphemy against the American Creed. That's according to George W. Bush on October 19th, 2017, where he said those words. And so if you Googled it, you could find the article. It had to do with the speech he was giving where everybody was perceived he was bad-mouthing President Trump, but he never mentioned him by name, so it could be tacked onto all sorts of people. Anyways, do they take that serious? Right? You use the word blasphemy as a president. Well, that's a religious word, mostly. Then you look at the definition. Well, not necessarily back in the old days, was it? But normally it was tied to, some kind of sin against God. So, well, what is this thing, anyways? I'd never heard of it until then. Sorry, I grew up here my whole life. Didn't know there was such a thing as the American Creed. But there is. And it says, I believe in the United States of America as a government of the people, by the people, for the people, whose just powers are derived from the consent of the governed, a democracy and a republic, a sovereign nation of many sovereign states, a perfect union, one and inseparable, established upon these principles of freedom, equality, justice, and humanity, for which American patriots sacrificed their lives and fortunes. I therefore believe it is my duty to my country to love it, to support its Constitution, to obey its laws, to respect its flag, and to defend it against all enemies. Okay, so, hey, it's not the Pledge of Allegiance, but it's called the American Creed. And there's a writer, so as I researched this, I saw that G.K. Chesterton had something to say about it. He's a well-known Catholic apologist. He said America is the only nation in the world that is founded on a creed. So a guy named William Tyler Page actually wrote it. And it's 1917. They had this national patriotic contest. Because guess what? Hey, we're going to go into World War I. By Henry Sterling Chaplin, inspired by the fever of America entering the First World War. Right, the fever. That's exactly what they had. The goal was to have a concise but complete statement of American political faith. I'd never heard of political faith before, but apparently Americans have it. They have political faith. Right? That must be a subset of faith. Because faith is faith. What's political faith? I really haven't found a good definition for it yet. Inspired by thoughts on his way home from church in May 1917, having just recited the Apostles' Creed, well, that's something I do know a little bit about, used in most Christian churches as a statement of belief. Okay, so it's a statement of belief. Blah, 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 blah. He took it from the Constitution, Gettysburg Address, Daniel Webster, other people's words. The American Creed has historically been violated by group-based discrimination, such as against African Americans, and it has been challenged by group-based attempts to correct the resulting inequalities, such as affirmative action. The American Creed is the title of a resolution passed by U.S. House of Representatives on April 3rd, 1918. It is a statement written in 1917 by William Tyler Page as an entry into a patriotic contest. Now, why is that important? Well, I thought it was interesting because George W. Bush is the one who said it. And in 1991, his daddy, the groper, George Herbert Bush, signed into law a law that was called Education Day. It was Public Law 102-14 of the 102nd Congress. And that law, Education Day, I remember this was passed by the House, passed by the Senate, signed into law by the President. So this is what the political class of America believes. 105, Stat 44, Joint Resolution. Whereas Congress recognizes the historical tradition of the ethical values and principles which are the basis of civilized society and upon which our great nation was founded. Okay, so somebody's great nation is founded on this. Whereas these ethical values and principles have been the bedrock of society from the dawn of civilization when they were known as the 7 Noahide laws. So the political class believes that we are governed by the 7 Noahide laws, and those are the 7 Noahide, or the 7 laws that are the backbone of the Talmud. So I'm not saying they're Talmudic Jews. I'm saying they say they're Jews and they're not. Because George Bush is definitely not a Jew in the term of Jesus in the time of Jesus, where a Jew was, somebody who was from the tribe of Judea, or Judah, I guess would be the proper way to say it, tribe of Judah. That was a Jew. The only people that were Jews were from the tribe of Judah. Go figure. So, hey, it's based on 7 Noahide laws. Whereas, without these ethical values and principles, the edifice of civilization stands in serious peril of returning to chaos. Whereas society is profoundly concerned with the recent weakening of the principles that has resulted in a crisis that beleaguered and threatened the fabric of the society. Yeah, you can read the whole thing yourself, but our political class believes that we are governed by the 7 Noahide laws. Public Law 102.14, March 20th, 1991. Okay, so the people that are governed by the Noahide laws say that it's a blasphemy against the American creed, whatever they were talking about at the time, but this is the creed they were talking about. And so, hey, don't violate the creed, right? It's a blasphemy. Now, in blasphemy, under the Noahide laws, would be a reason to be put to death by decapitation, as I remember. Because according to the Talmud, the Noahide laws apply to all humanity. In Judaism, refers to all of human mankind. The Talmud also states righteous people of all nations have a share in the world to come. In Judaism, Noah, Hebrew, descendants of Noah, children of Noah, okay, refers to all human mankind. So the 7 Noahide laws are traditionally enumerated not to worship idols, not to curse God, to establish courts of justice. Now think about that, right? Not a court of law, not a court of equity, not a court of admiralty, not any of these other courts, but a thing called a court of justice, a particular kind of court. Not to commit murder, not to commit adultery, not to steal, not to eat flesh torn from a living animal. Okay, so those 7 laws of man to a Talmudic Jew have replaced the 10 laws of God. Go figure. They put the laws of man before the laws of God. And so, hey, no wonder we have the problems we have. All right, so let's get into this deeper. Rob Reiter email address, courtofrecord@aol.com. That's courtofrecord@aol.com. Please donate if you can. My PayPal account is email address, Rob Reiter, ROBBRYDER@aol.com. Or snail mail, Robert Ratlewski, 10955, 14 Mile Road Northeast, Rockford, Michigan, 49341. So that introduction, I'm going to try to fit it into what I was going to talk about anyways. So what I first really want to talk about is you should watch With Liberty and Justice for All, which is the video just before this one that I did. Gentleman Craig Costello from New York, where we filed claims into his court case and against the state of New York, and the judge made the state answer. Well, hey, we got answers now. So let's see what that was all about. Okay, so where would I go to start? I guess that we should look at what it was first, right? So I'm not going to, obviously, if you watch the video that I just mentioned, Craig can explain it to you because I have him on TalkShoe, and or recording, I should say, and he's the one telling the story what happened. So I really believe you should listen to it. So we had a case in the Village Justice Court, Village of Amityville, New York, right? And this was a traffic case with 3 different violations, right? And that's why there's 3 different docket numbers, 1, 2, and 3, different charges basically. And he had been to these cases prior. So he has one here at Amityville, and he also had one in Babylon. Go figure. Amityville, the Amityville Horror, Babylon. Well, that'd be biblical. So let's go scare the devil, right? Scare the devil out of them. And they were both the same day, because Amityville has court at night, like 6 o'clock. So this would have been at 6 o'clock at night, and his other court case was like 2 o'clock in the afternoon in Babylon. Anyways, enough of setting up the story. So this is what we had put in to whatever the charges had been that came on, traffic tickets, for lack of a better term. Uniform law citations, I think they call them here in Michigan. But it was a notice of claim affidavit, deprivation of rights under color of law, identity theft, opportunity to cure. So Craig Allen Costello, being duly sworn, hereby deposes and says he has been victimized by agents of New York State, including identity theft, simulation, legal process, impersonation of public officer, deprivation of rights. New York State is negligent in the performance of its fiduciary duties to the people of the state of New York. Claimant offers New York State this opportunity to cure its negligence in lieu of claimant filing a formal claim with New York State Court of Claims against the fiduciary and its agents. So one other part about the story, this one was at 6 o'clock at night. When we put basically the same piece of paper for Babylon and put it into the Babylon court case, they were freaking out in the office. And they called people into the office. And you could hear them talking very loudly through the door, and so forth and so on. On the second time around, then when court started, I should say, so this is the 2 o'clock session. So when court started, Craig was the first one, and the judge didn't act like he was a defendant. He said, "You have a claim against for the state of New York," or he may have said to the city attorney. I have to go listen to it. But he was there. He was being recognized as being there, having a claim, not being a defendant. So he went to the second one at 6 o'clock, and they started the court case. They said, "All rise," and everybody stood up. And then the judge looked at the crowd, because there were quite a few people out there, and said, "I ask you all to remain standing and join me in reciting the Pledge of Allegiance." Did an about face and faced the flag and led off reciting the Pledge of Allegiance. From where Craig was sitting, it looked like everybody was saying it. He did too. So they all did the Pledge of Allegiance. Now, I'd never heard of that in court before. Right, that they started with the Pledge of Allegiance. But if you go read about the Pledge of Allegiance, it's an oath. Right? And so, before they took the Pledge of Allegiance, nobody in the court was under oath. And after taking the Pledge of Allegiance, everybody in the court is under oath. So, and then what happened, right? And so this is, I'm not going to read this whole thing because I got lots to read. So this is what we put in: adjudicated facts, negligence, just pointing out the things that were wrong with the ticket. So let's go look and see how they answered. And so the judge asked the town attorney, who was actually assistant district attorney, how long it was going to take to have an answer. And he said, 2 weeks, Judge. Not very happily, saying it would be a couple weeks. But it was, because this is the second time in the same day this happened to the same guy. Interesting how that all works out. So what did they say? So we got an attorney reply. And because this is the best picture, although it's the last one, I just want to show you something. I'm not going to start here with this, but it's in some kind of blue folder, right? That's hinged at the top. So if you've ever seen those holes at the top of paper, if you look at court cases, a lot of times you see these holes at the top. Well, that's what this is. That's the type of folder that's going to leave those holes. And it's eggshell blue. And somewhere in my background, and listen to this stuff, early on, the eggshell blue was ecclesiastic. I don't know if that's true or not, but so let's see what they had to say, since they had to answer. Right, this is an answer. One of those things they talk about in court cases. So it was affirmation and opposition against the people of the state of New York, against Craig Allen Costello, Village of Amityville Justice Court, County of Suffolk, colons, State of New York. Now what is that? Because it should be Suffolk County. I don't know who the County of Suffolk, State of New York is. That is an improper venue for me. That may be where they're from, but it isn't where I'm from. They want me to be from there, right? They're the people. With a capital P, not a lowercase p, right? A subset. So, I, William J. Reynolds, Jr., an Assistant District Attorney of Suffolk County, that's better, am admitted to practice in the state of New York and do hereby affirm, under the pains and penalties of perjury, that the following is true. I appear counsel to Thomas J. Spada, District Attorney for Suffolk County, and Attorney of Record for the people of the state of New York, and Attorney of Record for the people, right, capital P, people of the state of New York, and pursuant to the rules of the Appellate Division, Second Department, submit the following response to defendant's motion. Now, we can make all sorts of hay about, hey, the dude using the middle initial, and so is this guy, because that isn't their full legal name, and this is supposed to be a legal matter. But if they're answering into a different venue than those laws apply to, then, well, that'd be done different. Nevertheless, that ain't your full legal name. So that isn't who you are. In fact, he put his in uppercase, but this one he put in proper case. I appear to counsel to Thomas J. Spada, District Attorney for Suffolk County. Now, you know what that is? Thomas J. Spada, District Attorney of Suffolk County. That is a legal fiction being used to replace the true identity of a man that Thomas J., whatever his middle name is, Spada is. Right? They created this legal fiction. The statement made, now, we go on. So that is a legal fiction, right? That would be doing business as. Now, you can do that if you register the doing business as, either in the county or the state, depending on your state. But if you don't, then you're doing business under an unregistered name, and that's a misdemeanor. So if Thomas J. Spada, comma, District Attorney of Suffolk County, isn't registered as a DBA, wherever you DBAs are in New York State, well, then it's an unregistered DBA. And one more thing you could put against him. The statement made in this affirmation are based on information and belief, the source being the files of this office and the applicable law, and on that basis, I believe them to be true. So what files does he have in this office? What is this office? What files do they have? Defendant, Craig Allen Costello, right? So the defendant is his legal person, not his natural person, because it's an uppercase. Right? It's him doing business as himself. Not him doing business as with a assumed name, like with a middle initial. No, he's doing business as himself. But this is the name of his legal person. Defendant, his legal person, is charged under docket number AM number with 1 count operation while license or privilege is suspended or revoked, aggravated unlicensed operation in violation of vehicle and traffic law, and 1 unlicensed operator in violation of some other VTL, and 1 count no seatbelt. So that's what he had, right? Aggravated unlicensed operations. Like, hey, apparently it's not the first time Craig had this. He may have done it once or twice. I think he had the same charges in Babylon that he had here. He got unlucky at some point and they started picking him up. So there you are. Okay. Page 1. Page 2. I am submitting this affirmation in opposition to the motion that the defendant filed with the court wherein he requests an order dismissing the several accusatory instruments that have been filed against him upon the grounds that the said instruments are defective. That's a pretty good way of saying that. I'm not really so interested in the dismissal part, but okay. Defendant's motion to dismiss the accusatory instruments as defective should be denied. So really, in their eyes, what we did is we put in a motion to dismiss, right, because the accusatory instruments are defective. Defendant moves this court to dismiss the accusatory instrument charging the defendant with the said traffic violations. In support of this application, defendant states, so what do we put in? We put in an application. May have been called a motion, but he says it's an application. In support of this application, defendant states that the simplified informations are legally insufficient. Defendant claims that accusatory instruments fails to allege the legal name and true identification of the defendant as to violate his rights under color of law. Defendant claims VTL is not a proper legal citation. Defendant claims no legal name of police officer is subscribed. Defendant claims that Amityville Village Court is not a court of New York State. Right? Maybe state of New York, but it's not New York State. Additionally, the defendant claims that because courtroom furnishings include a gold fringe flag of the United States, and if the defendant is under military rule, then the officers have a duty to enforce organic laws and protect claimant from belligerents. Hey, this man ain't lying. We said all of these things. Information serves to inform, and information serves, 1, to inform defendant of the nature of charges against him, and 2, to protect him from being prosecuted twice for the same crime. Which is really what they're doing, because if you look at the case numbers on any different pieces of paper that you have for the same case, you may find variations in the numbers. Like sometimes they add zeros, or sometimes they use the date as not 2017, but 17. But it could be 2017 with the same numbers after it. Right? So it's like they're doing 2 different jurisdictions at once anyways. So these are the things it's supposed to do, but it doesn't do any of those, right? It doesn't inform the defendant of the nature of the charges against him, because they're not addressed to you and your legal name. And it's certainly not protecting you from being prosecuted. As to defendant's first claim, pursuant to 18 U.S.C. 242, deprivation of rights under color of law, when, hey, that's good. He knew what we were talking about. We were talking about 18 U.S.C. 242. Which says, well, I'm not going to read that whole thing because they wrote it. Well, maybe I can. When under color of any law, statute, ordinance, regulation, or custom willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, penalties on account of such person being an alien or by reason of his color or race than are prescribed for the punishment of citizens shall be fined under this title or imprisoned not more than 1 year or both. And if bodily injury results from the acts committed in violation of the section or such acts include the use, attempted use, or threatened use of dangerous weapons, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts, including kidnapping or attempt to kidnap, aggravated sexual abuse, an attempt to commit aggravated sexual abuse, an attempt to kill, shall be fined under this title or imprisoned for a term of years, for life, or both, or may be sentenced to death. They ain't fucking around, brothers and sisters. That is the law. That's 18 U.S.C. 242. That's deprivation of rights. When somebody deprives your rights, right, they're in the slippery slope. First, it's just the charge, then it's the charge with bodily injury, and then there's a charge with kidnapping. Well, when they put handcuffs on you, put you in the back of a car, take you down the road, is that attempted kidnapping? Yeah, man. Defendant fails to recognize that the simplified information state his full legal name as Costello Craig A. Right. Defendant fails to recognize that the simplified information, shouldn't that be with an S, S-T-A-T-E-S, informations, okay, there it is. Simplified informations state his full legal name as Costello Craig A. So in somebody else's jurisdiction, that is your full legal name, where it is recorded as last name, first name, middle initial, pursuant to the simplified information form. Accordingly, the supporting depositions state that the defendant's name as Craig A. Costello. Hey, somebody did it under oath. Both the simplified information and supporting depositions clearly state that the defendant's name. Neither the simplified informations nor the supporting depositions refer to the defendant under a pseudonym, nor do they conceal the defendant's true identity. Thus, it is proper for the police officer to list the defendant's name as it was required by the simplified informations. And so that sounds like a lot of gobbledygook. In fact, you might want to stop the film for just a second and just go ahead and read this. Get that thing off there again. Get rid of all these things on here. To see what they had to say. As to defendant's second claim, the assertion that VTL is not proper citation is groundless. Defendant fails to recognize that VTL is an acronym for vehicle and traffic law. The simplified information supporting depositions clearly state the violations listed for violations related to vehicle something or other. And as you can see, so this is why I don't like people to take pictures of things and send them to me, because you never get the whole thing in the picture. And I'm not picking on Craig or his mom for doing it. I'm just using it as an example, because anybody who sends me something, it looks like you have it all in the frame, but you don't, right? So we miss these little pieces on the end. Nevertheless, let's see what else they said. Other than the, defendant fails to recognize, you're correct. The defendant fails to recognize that as my full legal name. If I'm the defendant, then I fail to recognize that as my full legal name. Thus, defendant has proper notice of his violations under vehicle and traffic law. That's their story. As to defendant's third claim, defendant fails to recognize that the police officer's full name, signature is stated on both the simplified informations as well as the supporting depositions. Well, we never saw any depositions. All we saw are just the ticket. If that's the ticket, the thing that they give you. Right? And they didn't have a full name. It had like Officer somebody. Further, right, last name, Officer Ratlewski. Further, the simplified information state that the officer's registered badge, further, the simplified information state the officer's registered badge number. Thus, the police officer's full name is stated and the police officer has authority to issue appearance tickets. Well, that isn't true because every state, I'm gonna take a swag at this because I only know it to be true in the states I've looked. I'm gonna say every state has some entity that produces a certificate for somebody who's going to be a peace officer or a law enforcement officer or whatever, right? They get a certificate. Welcome to the club. If you don't have that certificate, you're not a law officer. And if you don't have that certificate in Michigan, so I'm sure it's the same everywhere else, you can't write tickets, right? You have to have had the training to write the damn ticket. Well, the name they're putting on those, that person doesn't have any license. You're not going to find that name anywhere. It doesn't exist. So the person that did the ticket doesn't have one. As to the defendant's fourth claim, defendant fails to recognize. Yes, I fail to recognize, right? I do not understand. I fail to recognize. They ask you, do you understand? You say, I fail to recognize. I bet you they say, case dismissed. As to the defendant's fourth claim, defendant fails to recognize that the simplified information state the court code relative to Amityville Village Court. The court code signifies that Amity Village Court is a proper venue within the New York State court system. Is it? Because they do have a code system up there. They got a number for the court. And I guess I'm going to have to FOIA to get a copy of that listing to see what it is. Or everything's got a serial number or, some other number besides, like you got a full legal name. You also got a serial number. You got your social security number. Well, so do these other entities that they've created as persons. They got their full legal name, and then they got something else, and the two together, you go from identification to authentication. One is the authentication for the other. As to the defendant's fifth claim, that he is subject to military rule because of the courtroom furnishing is without merit. Is it? The people, capital P people, have in no way contended that the defendant is under military rule. This court is the Village of Amityville Justice Court. As such, military regulations do not impact this court. Thus, the court has no duty to enforce the organic laws of the United States, as the defendant suggests. The court must not entertain absurd accusations. Right. The court has no duty to enforce 18 U.S.C. 242. Village of Amityville Justice Court. This court is the Village of Amityville Justice Court. As such, military regulations do not impact this court. Thus, the court has no duty to enforce the organic laws of the United States as the defendant suggests. Can you believe that a prosecutor could write such a statement? I wonder if he'd been drinking. Additionally, the people refuse to recognize the Social Security number. Shoot. I wasn't supposed to show Social Security number. Sorry. Anyways, because I did. If you were to see it, I did the numbering wrong. I put 333 when I put it on this paperwork. Unintentionally. I didn't do it that way on purpose. But, hang on just a second here. Look at something. 34, 32. Okay, so I'll take care of it. Hang on just a second. Pause. Okay, so I'll take care of that snafu later. Continuing on. was that down. That was number 4. That was what I wanted to use. Okay. And then so now we get to the blah, blah, blah. So what did he do? He went through all the points that Craig had made and gave his answer to each one, telling the court they didn't have to enforce the laws of the United States. Thus, for the above reasons, the simplified information is sufficient to put the defendant on notice of the charges against him. Therefore, the people, capital P people, asked the ruling from the court defendant's motion as to facial sufficiency should be denied. Not factual, as to facial sufficiency. You know what? We made some errors apparently in our wording or something, right? But not to the substance, right? Just to the appearance. However, further relief. The people further ask that the court grant defendant no relief beyond that requested in the defendant's motion. Yes, that is what it says. It says the people further ask that the court grant defendant no relief beyond that requested in the defendant's motion. Well, did he ask for relief in this motion? He certainly did. Hey, we could probably take a look at it. Let's see what we asked for. What did we ask for? Claimant asked by motion in order to dismiss the dockets, discharge charges, and he received reasonable attorney fees and other relief the court deems just. And the prosecutor is agreeing. The people ask the court grant defendant no relief beyond that requested in the defendant's motion. Give him what he asked for. All other requests not specifically addressed herein are denied as improper pursuant to some article of some CPL. Wherefore, it is respectfully requested that the defendant's motion be decided in accordance with the people's affirmation in opposition. The people announce their readiness to proceed to trial pursuant to CPL 3030. William Reynolds, blue ink signature, Assistant District Attorney, 16th of October. Sent it to Craig, right? Hey, this time they sent it to the proper address because he got to his mom's house. CC Clerk of the Court, but they didn't say what court. So that's where we are now. This just happened this week, and I don't know what it means yet. Craig's going to have to go down and talk to him and say, well, how about my relief? Because he had been told at the time he wouldn't have to come back to court. It could be all done administratively. That's why go listen to that before you comment too much on what was said here. Get the whole context, right? But good little points to gather on this thing. Absolutely sure. Absolutely. So, okay. So that was that one. Well, and that was based on something that happened a couple weeks ago. So in between, I've been writing other ones, trying to figure out what to do next. And I wanted to do one against title insurance, right? So I did one for a guy. Where this is his policy. Will be his policy, and this is what we sent to them. Okay, so anybody who has a house has title insurance. And no, that isn't probably 100% true, but close enough. If you find that policy, it'll be a few pages, and it has conditions and stipulations. And one of them is where notices are sent. All notices required to be given the company and any statement in writing required to be furnished the company shall include the number of this policy and shall be addressed to Consumer Affairs Department, P.O. Box, whatever it is. Well, hey, let's send them a notice of claim. On what, you may ask? Well, there we go. So up here was the dude's name, address, blah, blah, blah. Lawyers Title Insurance Company, because that is the name of the company, care of the Consumer Affairs Department. That's the address they want you to send it to. But I'm sending it to the Lawyers Title Insurance Company. Notice of claim and claim upon policy for damages. Unlawful conversion of claimant's rights, titles, and interests by policy insured. Policy number insured. So the insured is J.P. Morgan Chase Bank, N.A. The property address is in Florida. The claimant, being duly sworn, hereby deposes and says he, in partnership with his wife, both in their full legal names, are the real parties in interest to the insured real property and personal property incorporated by reference within the real estate transaction that necessitated this policy to cover losses caused by the insured. Because in their case, the insured is actually the bank. It isn't the owners, right? It's the bank that's insured. Well, why is the bank insured? In case the bank makes a mistake, right? So their insurance can pay it. So we're going to put a claim against their insurance. The policy insured, J.P. Morgan Chase Bank, N.A., has simulated a legal process, deprived claimant of his rights, clouded legal title to claimant's private property, and swindled the claimant of his legal tender and interest in the land from which claimant demands relief. Take judicial notice. In violation of 12 U.S.C. Chapter 2, the insured is not registered with the Office of Comptroller of Currency. I did this a couple weeks ago, so I don't remember exactly what Chapter 2 says, but I do know that NA ain't there, right? National Association might be, but there's no J.P. Morgan Chase Bank, comma, NA. It doesn't exist. J.P. Morgan Chase Custody Service prepared the mortgage. So now this is looking at different pieces of paper, such as the mortgage, right? Deed of trust, right? And so up at the top is somebody who prepared it. So that's what we're talking about. Whoever prepared it, dated May 13, 2015, stating the borrower is a legal fiction, Lori A., as a married woman, joined by her husband, right? So that's the name in the borrower line. They don't put your name. They don't put Robert Allen Ritluski. They put Robert A. Ritluski or Robert A. Ritluski, single man. Right? They create a legal fiction. So whatever's in the borrower line is the borrower, not you. That. Well, that's a legal fiction. Doing business as an assumed name, basically. And so if that hasn't been registered, again, hey, somebody's committing a misdemeanor every day. Well, you didn't put it on the paper, right? An attorney did. So they created this legal fiction to hide your identity. And they did it on the mortgage, they did it on the warranty deed or grant deed, whatever you call your deed, and they did it on the title insurance. Lori A., okay, so this legal fiction, and that the lender is J.P. Morgan Chase Bank, N.A. This unlawful conversion of claimant's legal name by J.P. Morgan Chase Custody Services adversely affected claimant's rights, titles, and interest to real and personal property. J.P. Morgan Chase Bank, N.A., the insured, never executed a bilateral business contract with claimant, invalidating any lien on the insured mortgage upon the title. The insured did not execute the mortgage agreement with the borrower. The insured cannot lend as it is not a regulated national bank. The insured is an unregistered assumed name. Sunmark Title Insurance Company prepared a warranty deed, submitting an unregistered legal fiction, assumed name, right? And so this time they put his name first, and Lori A., husband and wife, right? They flipped it around. Now she's not a married woman joined by her husband. Now it's him and Lori A., husband and wife. That's how the warranty deed is. So this is the grantee on the warranty deed. So the grantee is the one that's supposed to be getting the property. Well, that isn't the same as the borrower that got the loan. So the borrower and the grantee don't have a damn thing to do with each other. Right? The borrower can't put a loan against the grantee's property because it ain't the grantee. So, instead of real party of interest, let me start. Sunmark Title Insurance Company, warranty deed, submitting an unregistered legal fiction assumed name as grantee instead of real party of interest legal names, right, Robert Allen Rutluski, and omitted, including grantee social security numbers, unlawfully converting claimant's ownership rights to others. There was a place on there to put social security numbers on their grant deed, or their warranty deed, and they weren't in there. Because those social security numbers aren't tied to these people, to this legal fiction. It's tied to a man, and a woman. Schedule A of the policy states the unregistered assumed name, right? So I believe it's the same as this up here, as this one. As the party, the title to the estate of interest and land is vested in. The same unregistered legal fiction is on the warranty deed, right? So on the Schedule A, where it talks about who is entitled with a fee simple title, right? It's the name that's on the warranty deed. Right? The title to the estate or interest in land is vested in. And I'll show you that in just a second. The claim, the same unregistered legal fiction, is on the warranty deed. It is claimant's belief that no abstracted title or certificate of title has been executed to evidence the title vested to the grantee, thus invoking provisions of the policy for the benefit of the claimant. And that's because the people that they say the title vested in don't really exist, and they didn't really invest title there, right? So you're not going to find them on an abstracted judgment or an abstracted title, which is how about half the states are done, or a certificate of title, which is how the other half of the states are done. It is a crime in the state of Florida to do business using an unregistered assumed name. Policy insured J.P. Morgan Chase Bank has conspired with others to simulate legal processes under color of law using unregistered assumed names, violation of the laws of the United States, and causing deprivation of claimant's rights. Principals of lawyers' title insurance company would be engaging in misprision of felony and liable for prosecution by the Florida Office of Insurance Regulation if it were not to investigate and settle claimant's claims for damages to the fullest extent of the law. This affidavit made to me, claimant demands relief for loss and damages caused by insured and covered by that policy. So this went to the title insurance company. Just quickly, we won't spend too much time on the policy this time. Wait and see what comes back. But here's the Schedule A, right? Name of insured, J.P. Morgan Chase Bank, N.A. They don't exist. The estate or interest in land which is encumbered by this mortgage is fee simple. Title to the estate or interest in land is vested in this legal fiction. Show me the frickin' title. Show me that this is a registered assumed name. If you can't, well, then it's title fraud. Right? The insured mortgage and assignments thereof, if any, are described as follows. So even on this piece of paper, it's saying, well, this is who has who it's vested in, this legal fiction in number 3, and legal fiction number 4 in number 4 apparently took out a mortgage. But this legal fiction in number 4 isn't the same as the legal fiction in number 3, so how can the legal fiction in number 4 encumber the property of the legal fiction in number 3? I don't believe they can. Blah, 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 right? Signed, sealed, delivered. Schedule B, this is the one that exceptions from coverage, things that wouldn't be covered. I find this interesting that, so it goes 1, 2, 3, and then it goes to 6. Where's 4 and 5? They're not in here. But what's in there is items number 2 and 3 above are hereby deleted. Okay, so now we're going to go from 1 to 6, but what about 4 and 5? Where are 4 and 5? Interesting. Valid only. Okay, so here's reasons for executing the insurance. Title to estate or interest described in Schedule A being vested other than as stated herein. Any defect in or lien or encumbrance on the title. Unmarkability of the title. Lack of a right of access to and from the land. The invalidity or unenforceability of the lien of the insured mortgage upon the title. Right? Because it ain't the same legal fictions. So there's a few of them in here. This is the title to the estate or interest in land described in Schedule A being vested other than as stated therein. So that not, so they need to show you a title that has that legal fiction on it, or they didn't do it. And that's a reason to invoke the coverage. Any defect in or lien or encumbrance on the title. Any defect in or lien or encumbrance on the title. Any. This one has this thing here. Concrete drive extends into easement on south side of said lot per survey prepared by Bill Hyatt, dated 5/3/2005. I talked about this before, that we're not actually, unless you have a driveway permit in Michigan from 3 different entities, then you really don't have access to the road. Hang on just a second. And so if your driveway extends across, like where the sidewalk would go through, and you don't have these 3 different driveway permits on record, well, technically, hey, you just broke the law. So then, if you give a cop your address on on your driver's license, that's easy enough to look up if they were keeping the database to say, well, you can't be on the road. How did you get to our road from that property, right? You don't have authority to cross the easement, although it's your property, and all roads are built on private property. They're not built on public property, right? They sell you the lot up to the center line of the frickin' road. So it's just one of the tricks they play, but. Okay, so that's what happened, right? And we're sent this in, and we're going to see what they have to say. But if you have title insurance, it could either be a lender's policy or an owner's policy. And in an owner's policy, they're supposed to defend your title for you. And in a lender's policy, they're supposed to pay you if the lender doesn't do right, is the way I'm looking at it. Because these people have already lost their house, right? So there's probably already somebody living in it. But they were still damaged, and 3 times damages against loss or damage. Well, they had both. All right. So that was one I did. We'll see how that goes. It's been mailed, and we're tracking it on certified mail. We'll find out soon enough. When I looked on Friday, it was still in transit. Okay. So one other type I did for a guy in Georgia. We'll see how this goes. Okay. Now, I wrote this one after I'd heard about that thing that George Bush said. So I said, hey, I'm going to put that in the reason I'm coming. Claim deprivation of rights by state of Georgia. Blasphemy against the American creed. Let's go to the magistrate court of Houston County in Georgia. And so, full legal name being duly sworn hereby deposes and says that the case, regardless of the style, because like I said, sometimes they put a 0 in front of here, sometimes they leave 20 off, just have 17. Just depends on how they do it where you're at. But you'll have more than one style of court case going on. And probably more than one style of court name going on. Well, that'd be simulation of legal process. A is a simulation of legal process. Under color law, causing deprivation of claimant's rights. The claimant believes that persons may only use their legal names in legal matters. And it to be a blasphemy against the American creed for an officer of the state of Georgia to engage in a simulated legal process evidenced by the following facts. Right? I'm going to throw it on them. It's a blasphemy against the American creed for an officer of the state of Georgia to engage in a simulated legal process. Because it violates the American creed. Right? And so, if that means anything to the Noahide law followers, then be forewarned, attorneys. Plaintiff has no legal standing in the state of Georgia. It is not registered to do business in this state. If you're in any kind of court case and you look at the plaintiff's name, it's not a proper name, so it doesn't have any legal standing. Right? Only legal names can be used in legal matters. You can use a DBA or trade name, I guess, if it's been registered, but, well, show me the paper. Attorney for plaintiff has no legal standing in the state of Georgia. Said attorney name is not registered to do business in the state of Georgia, nor is it the name of an attorney and counselor at law authorized to practice law in this state. And so where it showed the attorney for the plaintiff, it had like Joe Blow, Esquire, and then a P number, right? And you would say, hey, that's their bar number or whatever. Well, I say, hey, that's a legal fiction, because it certainly isn't the guy's full legal name. So it could be a legal fiction, because corporations or companies can be attorneys, but it would have to have been registered. I'm going to say it isn't. I don't believe it is. Now they got to prove that now they need to answer and prove that it is. Nor is it the name of any attorney and counselor at law authorized to practice the state. So it isn't the name of a business, nor is it the name of a man. Defendant has no legal standing in the state of Georgia. It is an unregistered legal fiction because they're not using his full legal name. Claimant is real party in interest in title insurance policy insuring claimant's fee simple title. Said title insurance company is the claimant's attorney for service of process for any claim against his title, and claimant is not aware of properly executed service for a claim against his possession. Right? When you get title insurance, they become your attorney. So serve my attorney. No lender signed a contract to lend money to claimant secured by claimant's fee simple title. That they just can't get around. The state of Georgia Magistrate Court of Houston County appears to have also been victimized by the deceit of the alleged plaintiff and its attorney. In this matter, evidenced by court's judgment for a writ of possession awarded to an unregistered legal fiction, having no legal standing in the state of Georgia. So in this case, there's already been a judgment for a writ of possession issued against, the claimant. So the state of Georgia Magistrate Court of Houston County appears to have also been victimized by the deceit of the alleged plaintiff and its attorney in this matter, evidenced by said court's judgment for a writ of possession awarded to an unregistered legal fiction having no legal standing in the state of Georgia. Now that magistrate has to make a decision. Right? It may all be Satan's house, but this is how you divide the house, right? You set the judge against the false accuser that brought you there and let him do the right thing. and remind them of, hey, American Creed and that courtroom furnishings include a gold-fringed flag of the United States and symbol of our nation. Army Regulation AR 840-10 makes no provision for this style of flag to be displayed in civilian courtrooms, indicating this court has a duty to enforce the laws of the United States and protect claimant from belligerents engaged in an insurrection against the laws of the United States. Greg's prosecuting attorney failed to mention Army Regulation AR 840-10, although I believe we wrote it into his paperwork. The State of Georgia Magistrate Court of Houston County judgment unlawfully converted claimant's fee simple title to the use of others in violation of the organic laws of the United States, from which the claimant demands relief, including the acknowledgement by the State of Georgia of claimant's fee simple title. This affidavit is made in my personal knowledge and is sworn as a witness. I can testify competently to the facts of this affidavit, so don't do any more than you have to. So he's going to file this into his court case in the magistrate court, which is it's the proper court. I'm going to get to that in just a second. We'll go look at why I believe we should be going to the lowest court, which is the city court, magistrate court, district court, so forth and so on, where misdemeanors and traffic violations are heard, and where you get married, whoever does marriages and that kind of stuff. Okay, so this is a style going into a foreclosure, but really it doesn't really matter what the reason is that they brought you there. What matters is these things are the same all the time. That the plaintiff doesn't have any standing, the attorney doesn't have any standing, the defendant doesn't have any standing. Right? It's a simulated legal process, and that invokes 18 U.S.C. 242, and even a prosecuting attorney knows what that means. D. One more. Which one did I do? Which one did I do? Okay. This was into a criminal case. Or will be. If the guy does it, I don't know if these people even do it. I write it off and send it to them, but I can't put it in, right? So all the time, the same thing. Put your full legal name, call yourself the claimant, put your social security number, claim it, address, city, state, phone, claim. Those are all yours. You're doing this as an affidavit. You're swearing that shit's yours. And you're going to send it, in this case, to the state of Michigan, right? The 72nd Judicial District Court. But it's still the state of Michigan. The 72nd Judicial District Court is like an agency of the state of Michigan. But the state of Michigan is still, if you were to look at their envelopes when they send mail out, it says state of Michigan, and they would have 72nd Judicial District Court, and then the address. That's the return address, right? So that's what I'm going to send it to. Full legal name, being duly sworn hereby deposes and says, here's another style I did, right? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. And the reason I did that is, well, that's what the judge did. So I'm not going to wait for the judge to do it. I'll do it myself. Right? I'll salute the flag. I did it for 8 years. No big deal. Case 17 PO with some X's. Adjudicated in. So here's a case that's gone from the lower court, the misdemeanor court, or where all criminal matters started, which is in this case the 72nd Judicial District Court, and it's moved to a higher court, the circuit court. That's the way we do it here in Michigan. However, it started in the lower court. So go back to the lower court, go to the beginning where the error was, and point out the error. Right? So the case was adjudicated in the 72nd Judicial District Court. Is a simulated legal process under color of law that deprives claimant of his unalienable rights. Claimant believes that persons may only use their legal names in legal matters, and it to be a blasphemy against the American Creed for officers. Hey, buddy, before you change that, state of Michigan, I got to change that. I was copying. This is what happened to you copy and paste. State of Michigan to engage in this simulated legal process is evidenced by the following facts. State of Michigan, County of St. Clair is an improper venue with no authority to adjudicate state law. Complaint felony for the case is unauthorized process under Michigan compiled law, MCL 75217C. It is void of any victim or complainant, void of a complaining witness signature, has not been sworn before a judicial officer. MCL 333-7403 is a public health code statute. So this guy is being charged with a public health code statute, not a criminal statute. A public health code is administered by the Department of Public Health, not Det Brisby, alleged complaining witness. Only Department of Health employees have authority to request warrants and must do so by affidavit in accordance with MCL 333-2242. There is no evidence that an affidavit was filed by the Department of Health in this matter. Senior Assistant Prosecutor is concealing her true identification while prosecuting false claims in an improper venue against an unregistered legal fiction, last name first middle, the defendant, in an attempt to coerce claimant to assume the false identification to extort claimant's wealth using claimant's signature on a unilateral contract acknowledging claimant to be indebted by bond. Courtroom furnishings of the State of Michigan 72nd Judicial District Court include gold fringe flag, United States, and symbol of our nation. American Army Regulation 840-10 makes no provision for this style of flag to be displayed in civilian courtrooms, indicating this court has a duty to enforce the laws of the United States and protect the claimant from belligerents engaged in an insurrection against the laws of the United States. State of Michigan 72nd Judicial District Court appears to have been victimized by deceit of Senior Assistant Prosecutor P's and X's as it issued a false judgment that has damaged claimant's liberty, facilitated the embezzlement of claimant's private wealth. Claimant seeks an administrative remedy to his persecution by enemies of the state and ask agents of the fiduciary, State of Michigan, to cure fiduciary's error and see to claimant's relief. Right? We don't want to go to court. We want an administrative remedy. I'm not trying to continue a court case. I'm trying to end it. So there you go. One other way to do it. Now the reason about this lower court, just really quick. In Wikipedia, under recorder, judge, right, it's a judicial officer, in England and Wales and some other common law jurisdictions. Well, since, our laws follow the laws of England and Wales, we probably have recorders. In the Court of England and Wales, the term recorder has two distinct meanings. The senior circuit judge of a borough or city is often awarded the honorary recorder. However, recorder is also used to denote a barrister or solicitor who sits as a part-time circuit judge. So the highest judge and the part-time judge are recorders. Right? One's an honorary office and one is, right? So that'd be honorary recorder. So maybe that guy doesn't have the powers. I don't really know. But these barristers could have. Or they both do. But I'm going to say because it's the senior circuit judge of a borough or city, well, we're talking about a municipal court judge or a district court judge, which has replaced our municipalities in Michigan. And this is the judge in New York, in Amityville, and in Babylon, right? These are the judges that made these decisions were the circuit judges of those municipalities. And one of them led the whole entire room in the Pledge of Allegiance. Right? In England and Wales, originally a recorder was a certain magistrate or judge having criminal and civil jurisdiction in the corporation of a city or borough. Such incorporated bodies were given the right by Crown to appoint a recorder. He was a person with legal knowledge appointed by the mayor of the corporation to record the proceedings of the courts and the customs of the borough or city. The recordings were regarded as the highest evidence of fact, right? He has the court of record. He has the record. Whatever that record says is what the court is going to go by. And so if there's a record that says that this legal fiction is the name on a warranty deed, and you say it's your property, and they say, let me see your driver's license, they look at your name and say, well, that's not the name on the record, guess what? You lose. The court of record spoke. Whatever in the record, it's the highest evidence of fact. So we need to change the record, not argue with it. So, well, there's an error. I'm the owner. Here, let me tell you why. Typically, the appointment would be given to a senior distinguished practitioner of the bar, and it is therefore usually executed part-time only by a person whose usual practice as a barrister. It carried a great deal of prestige and power and patronage. The recorder of a borough was often entrusted by the mayor, corporation, nominated, parliament, blah, blah, blah. So if you're from England or Wales and you're watching this video, right? Who are we talking about? That's the guy you need to go see who's over the municipality. I'm just saying it's the same here in America, only different because is what it is. It's the way we're doing it. The honorary recorders, who are also senior circuit judges, are authorized by the Lord Chief Justice to wear red robes while sitting in court. Well, that's how you can tell who they are. These robes are based on the design of robes, right? It's like, hey, go find the guy in a red robe and take your complaint to him. Write it to him. What else do we have? Due to the reorganization of courts, especially with local government reorganization has occurred at the same time, some titles bestowed by one council may be held by a senior resident judge sitting in another borough. A prominent example is the recorder of the city of Westminster, who resides at the Crown Court situated in the London borough of Southwark. Okay, so pay attention. Now we're talking about a guy called the senior resident judge. Go find him. Right? Ask him who's the appointed recorder. You got business with the king. Since 1971, recorder has also been used part-time judicial appointment in England and Wales, providing part-time experience of judicial officers. Part-time appointee as initially designated assistant recorder, review of promotion to a full recorder. Yada yada. Appointments are made by the Crown by royal warrant on the recommendation of the Lord Chancellor. Well, that's how you can figure out who these people are and go take your complaint to them, your claim that your rights are that you're being deprived of your rights. In U.S. and Canada jurisdictions, the recorder court is a local court of limited jurisdiction, most often hearing misdemeanor, traffic violations, and other petty criminal offenses. The recorder of New York City was one of the judges of the Court of General Sessions, a local court of general jurisdiction on criminal cases, and presided over most murder trials in New York City. Right? So you could have a recorder's court. There used to be a recorder's court in Detroit. I don't know if it's still there anymore. But now we have district courts. Well, that's who these people are. So I'm going to say the senior district court judge, at least in Michigan, is this honorary recorder we're talking about. But in that same office are part-time recorders, right? And so they could just be magistrates, right? Because they're doing administrative functions with some judicial. And why does it all matter? Well, because in biblical usage, in historical times, the recorder was the chancellor of the kingdom. Well, that's the top dog next to the king. He brought all weighty matters under the notice of the king, such as complaints, petitions, and wishes of subjects or foreigners. Right? You take your paper to the chancellor. He also drew up papers for the king's guidance and prepared drafts of the royal will for scribes. All treaties came under his oversight. He had care of national archives, of records. Right? He's got the records that matter as far as you're concerned. to which, as royal historiographer, he added the current annals of the kingdom. So, because what I've been showing so far is, people who have court cases and putting things back in. But if you don't have a court case and you want to go do something proactive, which is what I'm all about, you would send it to, apparently, the chief judge of the district court. And, we'll try that and see if we can, that's next week's business. See if we can find out if that's really true. So that's what's going on. But, hey, we got an answer, finally, to something. And right, all I want to know is, sorry that this taking so long. I don't know what's wrong with my computer. It's running slow. Come on. Blasphemy against American creed, according to George W. Bush, on October 19, 2017. Let's find out if they take it serious. And hopefully we can get an answer on, the rest of the story from Craig. Stay tuned for more. Have a great day. See ya.